My brother judges, learned members of the bar, ladies and gentlemen, I am very happy to be here with you all on the occasion of the 20th anniversary of the creation of this bench. This bench, as far as I recollect, was created in July 2004, and I came here as Chief Justice in November 2004. Just a few months after it was created. When I reached Chennai, took oath as Chief Justice, within 2 or 3 days I received a call from a judge sitting in the Madurai bench. And he was almost crying. I said, "What's the matter?" He said, "My lord, I have been sent here since July, posted here without my consent. My wife and children are in Chennai. My wife is ill, my children are ill, I am going to die," and this and that. So I said, "Brother, if there's a very grave urgency, I'll pass an order just now that from tomorrow you will sit in Chennai. No problem. We are one family. We all have to look after each other. But if you can wait for just a few days, I'm calling a meeting in the coming Saturday of all the judges of the High Court, including judges of in the Madurai bench, to create some system of sitting in the of judges in the Madurai bench." Because you see, the problem was at that time when I became Chief Justice, the sanction strength was 49, but the incumbents were only 25, which means there were 24, half the court was lying vacant, and a few judges were going to retire shortly thereafter. There was a big crisis. So I called a meeting of all the judges in Chennai, and I suggested that 5 judges will sit in the Madurai bench. Today I believe 21 judges are sitting here. So I said 5 judges will sit, because we had only 25 judges altogether. And I said they will sit for 8 weeks and they will come back. Another batch will be sent only after taking the consent of each judge. Without his consent, I will not send anybody to Madurai. And if supposing in the 8 weeks one of the judges has some urgency, his wife has fallen ill or something, he should inform me. I will come as a substitute in his place for the remainder of his term of 8 weeks. So we are one family, this is no problem, and that's how throughout my stay for 1 year as Chief Justice of Madras High Court, we functioned. When I came for the first time to Madurai, I think because I had joined in November, maybe this was in December or January 2005, the Bar Association held a welcome function in which I was asked to speak, and I quoted from Silapati Haram, which I had read in translation, where Kannagi burned the entire city of Madurai. This is Madurai. She burned because injustice was done to her husband. So I said, if you want peace and prosperity, justice must always be done. That is an example. And I said this in the city of Madurai, in the Madurai bench, that you will be burnt if injustice is done. Then when the regular proceedings started after that function, what I found was any case called out, the lawyer will stand up and say, "My lord, please adjourn the case. I want to get a lawyer from Chennai." In every case. So I said, then what is the use of my coming here if every case is going to be adjourned? See, the problem at that time is that the lawyers of the Madurai bench, they were actually district court lawyers, district court Madurai lawyers. And you know, district court lawyers know mainly civil law and criminal law. They have no idea of writ law, of service law, of taxation, of labor laws, and so many other branches of law which are only in the high court level. And they had no idea about all this. So in every case which was called out, the request was, "Please adjourn my case, I have to get a lawyer from Chennai." But today I am told that now the Madurai bench lawyers are doing as well, if not better than Chennai lawyers. This is what I am informed now. So you have pulled up your socks, you have now become high court level lawyers instead of remaining district court level lawyers. And I'm told you are doing very well. I was told yesterday by some lawyers, Mr. Isaac Mohan Lal and others had come to meet me, and they have some grievance that you have no original jurisdiction here, which I thought is wrong. There should be original jurisdiction, because the purpose of creating, the logic of creating the Madurai bench was that the litigants from southern Tamil Nadu, they had to spend a lot of money going to Chennai, because Chennai is in north of Tamil Nadu. So they wanted a bench which was closer, where they would not have to spend so much money. That was the purpose, as I was informed, of creating the Madurai bench. So the same logic applies for original cases also. Why should a litigant coming from Kanyakumari have to go to Chennai to file a original case? My brother R. Subramaniam is here. He should kindly consider this. I mean, look at the logic. The logic is that the people from southern Tamil Nadu should not have to spend too much money. That is why the Madurai bench was created. So, on the same logic, original jurisdiction, taxation and election petition and arbitration, all should be, I mean, if the case arises from these 16 districts, then they should be allowed to be filed in the Madurai bench on the logic of creation of the Madurai bench. So, I am requesting my brother judges to kindly take up this matter. This is a justified grievance which I was informed by Mr. Isaac Mohan Lal and other lawyers that they have. And also Mr. Isaac Mohan Lal told me that the strength of the Madurai bench should be increased, because there are a lot of cases being filed and the number of judges is not adequate. So that is also a justified demand. You know, my parent High Court, Allahabad High Court, has a sanction strength of 160 judges. So your High Court is it's a chartered High Court. It was formed before the Allahabad High Court. Surely the strength of the Madras High Court should go up to about 100. Today I believe the sanction strength is only 75. In my time it was only 49. But now I believe the sanction strength is 75. It should be raised to 100 judges at least. Then Allahabad High Court has 160. So I will only conclude by saying that when I was the Chief Justice here, I invited Mr. Isaac Mohan Lal to my chamber. And I said, I want to recommend your name for High Court judgeship. He was that time just 40 years of age. But he refused. I think he was earning much more than what a High Court judge. Today he would have been Chief Justice of India. I mean, this was almost 20 years ago. So we missed a good Chief Justice from Tamil Nadu. So with these words, I want to thank you all for having invited me. It was a pleasure to meet all of you. Thank you.
Thank you, my lords. It is always happy to hear Justice Katju.